here together, the men I wanted to add. Let's go to the agenda. To receive public input and comment on proposed amendment to planning and zoning ordinance, section 1287, section 12109, and section 12140, to include service and 20%. Right now, with our new ordinance, we don't have those in place. So we send it to planning and zoning, and refer it back to the jury. Ordinance add towing and storage. Open for comment. Yes, sir.
First of all, not as a planning and zoning person, as a person in the parish. All four of these things that y'all are talking about should not be in light industrial. Because industrial, the reason it's light and heavy depends on the environmental impact. And a junkyard, salvage yard, I haven't seen a wrecked vehicle that's not leaking something that's towed off the road. And DEQ regulations now say that those places have to have a concrete pad with a hazmat lip around it and a drainage catch basin, or they have to be in there for a certain amount of time. And y'all are trying to put them all in I-1, which would be light industrial, and they're not the same. There's two of them that could be in light industrial, because if you limit it to how long they can be in there for like a tow impound lot or a towing service, one of them 24 hours, one of them 7 days for insurance purposes. And then, but a salvage yard, once they go in there, that's forever. And they have to be, I mean, you need, if you're going to allow that at all, you would have to write a whole new ordinance, like the logging ordinance, like the heavy use ordinance, like an annual inspection, because that's the only way they're going to maintain their standards. Everybody on this, sitting in this room knows that a junkyard gets out of hand very quickly and becomes an eyesore and a blight.
So I got a question.
Okay.
You're speaking as a non-member of the...
Not planning and zoning, just a resident. Just as a resident. In other words, somebody lives here, and like most people in here, I don't want a junkyard next to me.
Okay.
But there's a change in here where you're changing, adding agriculture to the 300 foot or yard, 300 feet from agricultural residential. This whole parish is agriculture.
So can I ask you a question?
Mm-hmm.
As planning and zoning members?
No, he's got three.
Okay.
No,
Go ahead. Go back the other way.
If that's the feelings, then how did this come from planning and zoning here in light industrial?
It didn't come that way. That's the way we did not have a problem with, because the recommendation came up the first time, split two ways. Your engineer and legal counsel went back this way. Okay? It came up from planning and zoning, was okay, if that's what the police jury is going to do, listen to those two individuals as an engineer and legal counsel, then they concurred with legal. But I told them at the meeting, I was going to be here to voice my opinion that a just salvage yard is not light industrial. It's an environmental impact, which makes it L2 at the very least, and should be a strict ordinance on it. But that part that they put in here about agriculture and residential, why don't you just say there will be no salvage yards and junk yards in this parish, because the whole parish is agriculture, if it's not already commercial. And with that statement, you'll lose in court. Not a lawyer, but that's my opinion. You're taking their property rights. You can restrict them to death, but you can't take away what they're, in other words, you can mount restrictions on how they're going to do business and what they're going to pay every year and get inspected every year. But when you put that line in there, you're saying, no, you're not coming here at all. Period.
Thank you, Mr. McCoy. Mr. Johnson, court speak for planning and zoning.
Joshua Quinn, Chairman, Planning and Zoning. The way the recommendation went coming out of Planning and Zoning was to go to both the engineer and our legal advisor on how to rewrite. And the engineer was using some of the practices that are in other parishes, somewhat mirroring what goes on in other parishes. There's one change other than add light industrial. There's one change in the distance, which does add agricultural to the distance. We already had the residential requirement, and as a definition. So mostly it was fairly minimal changes, but this is by recommendation of both the engineer and the legal advisor.
Question.
Yes.
What was the discussion at planning and zoning? Was it a unanimous thought that it should be?
I think we had one, I believe.
Then I'm talking about from light industrial to industrial.
Yes, we discussed that, and we discussed that with the recommendation. We discussed the distance recommendation during the meeting, and that was to rewrite it was given to the option of the engineer and the legal advisor to write it and phrase it properly.
But the committee
We
was
discussed.
consistent.
We discussed keeping everything boxed into one. We had these recommendations already. We discussed them, and we discussed that was the direction to go.
Just like it said.
So this recommendation actually represents what planning and zoning wanted to do.
Yes, planning and zoning discussed it, so the engineer and legal advisor sent recommendations to us that this is what they would do, this is what we should do. We looked at the recommendations, said this was the way we're gonna go, have them write the ordinance, and we'll proceed that way.
We're talking about 200 feet of rain, so we're talking about still for 24 hours or 7 days, right?
This is discussing all those classified, the wrecking yards, all of them.
I think that's what
300 foot.
right.
So if you look at other parishes, that the intent is to keep those issues in industrial or commercial areas and not have them next to houses, next to farms, next to those items, and keep them put in industrial and commercial areas.
When it, in this situation, if 300 feet being classified as commercial,
If 300 foot is commercial, it would be, it falls in the classification. So, but, yes, absolutely.
but they're classified as commercial.
No, what it's saying is it can't be 300 feet from any residential or agricultural
Right.
property.
Right. So, if something falls in that classification, it's fine to put it there.
Mr. Williams, comment, please.
Mr. President, I'd like to call a point of order, please.
Thank you, Father. Okay.
I can't hear you guys if you don't use your microphones. I've complained several times, as well as other people in the audiences, and I really appreciate it, as do other people. The YouTube videos, when I try to watch those at home, it's just a garbage mess. I've also had people that have friends with normal hearing that have watched those, and they can't understand. The only person, I see Ms. O'Quinn talk tonight, so thank you, is Mr. Alvo, and I'd like to commend him for all he's doing. We
Thank you,
can
ma'am.
understand him,
Not at this
so
point. Thank
I
you.
appreciate it,
Yes,
and
ma'am.
that's all the time. Thank you very much. Sorry to interrupt.
Thank you very much. Mr. Moore.
Yeah, I guess a little bit disappointed in some of the way y'all operate. I heard Chris, Ms. Oakland, keep asking planning commission, like you're trying to make a point here that this is the public, this is the planning commission's animal. And I watch y'all not all the time, I watch y'all a bunch, whether it's a rezoning request or whatnot. The planning commission will do their duty. They send y'all's recommendation, and y'all kick it back to them. I don't know why y'all keep kicking stuff back to them once they do their duty. And I'll remind y'all They provided the language. They originally came up with this was way back about 16 months ago, back in August of 21. They met, they discussed this stuff, they had the language, they provided y'all the recommendation. And then on September 7th of 2021, about 16 months ago, it was on y'all's agenda, based on that recommendation, what y'all was gonna do with that. Well, y'all tabled it. That was 16 months ago. And then a few months ago, I asked, I figured y'all be working on it. It should be the public, once they ask for a rezoning request, it should be on the public to come back and remind y'all what's before y'all and make a decision on it. When I came back up here a few months ago, some of the comments were, well, we forgot, or, you need to remind us, and I'm like, really? When the public asks y'all to do something and it's on y'all's agenda, it should be the end of the public's responsibility. So it was over a year and 4 months that the planning commission did their job. Y'all didn't like the language, y'all tabled it, sat on it for over a year. And then that's fine, then you kick it back to them. And I'm hearing questions like, however this thing goes, you want to say, well, the planning commission, because you want their blessing. Y'all are backdooring this stuff. No one else operates this way. Once the planning commission reports to who they report to, that's it, they've done their duty. They had a rezoning request a while back. There was a stalemate, 4-4 vote. By state law, they don't have to have a positive vote, negative vote, whatever. It comes back to y'all, we've got no recommendation. Y'all kick it back to them, playing ping pong with the thing. So I'm just saying, when y'all do that kind of stuff, that's not in accordance with state law. That's not how you operate. You ask them to do their duty, they do it. Y'all are the governing authority. Y'all the ones that got to say so anyhow. You don't like what they come up with? Fine. Find what y'all did. Send it to the engineer, get your legal counsel and whatnot. But send it back to them so you can sit up there and go, well, this is the planning commission's language. No, their language was rejected by y'all. Then you wanted to seek your legal counsel and engineers, that's fine. You got that authority because y'all are the authority. But kicking it back to them on many different issues time and time again, I don't know why y'all do that. But be that as it may, I had to say that. My only question on the ordinance y'all are looking at, they've kind of addressed it, but they haven't. I heard Josh say they looked at other parishes. The 300 feet is my only question on what y'all are looking at. Other than looking at other, maybe Josh can answer this, other than looking at other parishes, my question is, where does the 300 feet come from? What's the justification for it? It's got to be some kind of justification or merit, or otherwise it's just a number yanked out of thin air because somebody likes 300 feet. So, now we'll keep in mind this is y'all's ordinance. It's not the district attorney's ordinance. It's not this planning commission ordinance. So when I ask a question like that, where does the 300 feet come from? This is y'all's ordinance. So y'all need to know where that comes from if there's justification behind it. If you don't know, I would hope you get an answer to that. Might be a justification for it, but I'd like to know what it is. That was my only question. Thank you.
Well, Mr. Jeff, I wanted to let you know I was asking those questions because I had one member stand up and said that he thought it should be industrial, not light industrial. So I asked Josh the questions. Because I wanted to know, was it just one member thinking it should be industrial and everybody else thinking it should be light industrial, but they just agreed to it because it did come from the legal advisor and didn't discuss it among themselves. So I take a lot of weight in what these guys say.
Well, I appreciate that. Y'all should. I'm just saying the ping pong thing I see that y'all send it back to them. I'm just saying by state law, by every other jurisdiction I fool with, which is about 24 of them, be it a parish, a municipality, whoever. Once the planning commission reports to the governing authority, that's it. There's no sending it back to them. It's back to y'all. You got the recommendation or no recommendation. Y'all got the authority to do with what you will anyhow, because it really, I appreciate you want to know, but like on zoning matters, it doesn't matter what they say. They can say, let's rezone it this way, give a positive thing, y'all can turn it down, or vice versa. They can say, turn it down, y'all can approve it. So there's no need to keep kicking it back. That's the only point I'm making, and not just on this issue, but others. And the fact that I've heard comments off of this board that y'all just found out like a couple of months ago, this thing's been going on 16 months. And you should be telling the public, please remind us when you have the public come in to go through the procedure y'all put in place to ask for a rezoning request, and for whatever reason you claim that, oh, we forgot, and please remind us, well, I mean, think about what you're saying there. The office, the staff should be the one reminding y'all, not the public once they submitted a request. So that was generally what I've seen, but the 300 feet is my question. I would like an answer to that one. Thank y'all.
Yeah, the reason we're amending our ordinance is because we don't have nothing on the ordinance discussing storage or towing. You don't have it. So why would we not ordinance add the storage on it?
No, I appreciate that. I don't really have a problem. JR had his comments he just made, and that's what I said. That's the only question I have on here, is just the 300 feet. And I'm just trying to point out other things on how y'all operate from what I've seen. I wish y'all cleaned up some of that, but the 300 feet, it may be a great number. I'm just saying, when I read a number, if there's no justification behind it, that's just a number yanked out of thin air. So I'd like someone to say, where's the justification for throwing that number? It might be great. Maybe it needs to be 1,000 feet. So if someone needs to know where they come from, and it can't just be, well, 5 other parishes have 300 feet. That's all I'm asking.
My question is, back in the past, when they went to put a mobile home park at John Katrina, which is sold in there, 300 feet designated as commercial. That's where the 300 feet came from. Most of it was agriculture, except for 300 feet was deemed commercial. Now where the 300 feet came from.
So the 300 foot that's listed here has been in our ordinances already. It's 300 foot for residential. Go to other parishes, go to Ascension Parish, it's 1,500 foot. I think Livingston is around 800 foot or so. I don't know exactly. I do know for sure Ascension's 1,500 foot. The 300 foot is much more lenient than what the 1,500 foot would be. 1,500 foot would put it to the curb almost. I mean, that would give you a distance out, you know, so.
That's
So
where
the 300 feet has always been here?
300 foot's always been there. It's always been there. It's listed, it's the same.
Let me just back, and that's fine. And I appreciate that explanation. But I will point out, I think JR had a legitimate thing. I know this parish has tried this in the past with hunting. So you got whatever the width of the property is, 400 feet, you try to do an ordinance. You can't shoot any closer than 250 feet. You basically then tell that person he can't hunt on his property. And that has been rejected by the courts. So this is kind of a similar thing. So, I think you got a valid point there. So I'm just saying, when you create numbers like that, whether it's already in the ordinance or not, you're trying to change it. Of course, like anything, flies until it doesn't, right? Until it's contested in court, and you can get a judge and say, well, that's unconstitutional. So, anyhow, I appreciate the answer.
Okay, any more comments? Some kind of inclusion on it now. You know, I just don't see putting a 24-hour storage in 7 days for a storage yard. That's impossible. It takes 7 days for it just be called, not just come out and expect them to be called. Who would want their vehicle impounded for 24 hours? Does it make common sense? Is it economically feasible? Put a burden on the people who have the rent, even if you're not the rent. You're going to fail me dealing with a limited order. Anyone have a copy of the order? If you don't, get a copy of the order. That's a limited order.
I understand all the back and forth between the zoning commission and so forth. From my point of view, the lowest common denominator of this property is in a residential area. Yes, it's agriculture. I don't mind cattle, cows, sheep, goats, horses, horse farms, riding academies, animal shelters. To me, that's agriculture. But the main issue for me and why I disagree with this ordinance change is your spot zoning in a residential
We gotta
area.
change this amendment to our ordinance. We don't have this in place right now. It's an amendment to our ordinance.
sorry, Mr.
It's an amendment to the ordinance, not a change, it's an amendment to the ordinance. We don't have this in place right now.
Right, but you're gonna put a junkyard in a residential area. Maybe that's moved. I know there was a judge involved.
That's not what this is saying. This is just giving regulations on how an area could fall under that. So we're not saying, this is not saying this can happen in a residential. This is saying it can't happen any closer than 300 feet.
Of a residential area. Because see, in my mind, that's residential. You have people all around that lot that look down on.
So you would prefer it to be 1,500 feet? You prefer it to be further?
I prefer it for not to be there at all, but I think that's already been determined by a judge. But when you keep this spot zoning in residential areas, I do have a problem with it. And I'm not sure that the people that are already there and residents are getting their 2
I
cents.
think we're being misunderstanding. First of all, we're not saying we're putting a zoning in the storage rectangle in place. But instead of doing it, we're letting our ordinance include this in our ordinance, what we're doing.
But then you're gonna allow it to be there, right? Am I misunderstanding?
No, we're not saying allow it. It's just gonna be ordinance. I mean, our ordinance. We had it stolen for a couple of months ago. No, we had it told you it was stolen.
Okay. Anyway, that's my 2 cents. I'm against, and I'm concerned with what I see as spot zoning where you're changing residential to something else, and then we have to, I don't want that next door to my property. Thank you very much.
Yeah, we'll put comments. Then we'll put the comment on the code, the public hearing, give it a follow resolution.